I'm Rob Sterne, founding director of intellectual property law firm Sterne, Kessler, Goldstein Fox. Today, I want to talk about the critical topic in the current patent office litigation landscape, demonstratives in post-grant proceedings after the America Invents Act. A party in patent office litigation at the Patent Trial and Appeal Board has a significant challenge in proving their case. The actual trial of an inter-parties review, covered business method review, or the future post-grant review is only a short hearing, probably 60 to 90 minutes total, before the Patent Trial and Appeal Board. And in most hearings, there will be no live testimony. So it is a far cry from the typical validity trial in the district courts or the hearing at the International Trade Commission. And the discovery in these contested proceedings is very limited. It is modeled in large part on the Patent Office's interference rules. So it is incumbent on advocates to use all available mechanisms to prove their case before the board. In their trial practice guide, the board has admonished counsel concerning use of demonstrative exhibits, surprisingly. Specifically, the guide states, the board has found that elaborate demonstrative exhibits are more likely to impede than help an oral argument. The most effective demonstrative exhibits tend to be a handout or binder containing the demonstrative exhibits. The pages of each exhibit should be numbered to facilitate identification of the exhibits during the oral argument, particularly if the argument is recorded, which they always are. And Rule 42.70b requires demonstrative exhibits must be served at least 5 business days before the oral argument and filed no later than the time of the oral argument. Now, it is prudent to prepare and file demonstratives at the beginning of the proceedings if possible, and I realize that's not always the case. For the petitioner side, if possible, they should be part of the petition, and for the patent owner, part of the patent owner's response. Make sure your expert and any fact witnesses submitting declarations support these demonstratives in full. Rule 42.61c requires a declarant to support any experiments in a patent or patent application. Consider providing a technical tutorial if technical issues are complex in the proceedings. Other demonstratives may include testing and other evidence dealing with inherency or unpredictable results as examples. In other words, if you plan to use demonstratives, remember the significant limits imposed by these proceedings and figure out how to use them at the very beginning of the proceeding to advance your proofs. Thank you very much.